Hello, welcome to What's at Stake in the Courts for Bodily Autonomy. We are going to get started in just 2 minutes, but if you would like to take a minute and put in the Q&A function and emoji that shows how you feel about the current state of bodily autonomy and your name and organization and pronouns, if you wish to share, we would appreciate knowing who's in the room. Thank you for taking time to join us today. I believe we're in webinar mode, which means that everyone should be able to see the Q&A function, but not the chat function. So again, feel free to drop in Q&A an emoji that shows how you feel about the current state of bodily autonomy, your name, your organization if you feel compelled, and any questions you have. We will end with Q&A after our presentation. Thank you. We're going to take just another minute to let people transition from their previous meetings. So welcome to What's at Stake in the Courts for Bodily Autonomy. If you would like, please use the Q&A function to share an emoji that reflects how you feel about the current state of bodily autonomy and your name and organization and pronouns if you wish to share. Thanks for being here, and we will get started in just another moment.
The emojis coming in seem very, very accurate.
Welcome, everyone. Thank you for making the time to join us to discuss the state of bodily autonomy and the United States Supreme Court. This is a webinar, so please feel free to use the Q&A function if you have any questions. Also, feel free to take a moment to react with an emoji that shows how you feel about the current state of bodily autonomy and your name and organization and pronouns if you wish to share. My name is Lichi Liang. Lichi is my first name, and I work as the Senior Policy Advocate at Northwest Health Law Advocates, or NoHLA. Today, we'll also hear from Vanessa Saavedra, the Senior Staff Attorney at NoHLA, Sadi Zapata Nachwaya, the Health Policy Program Director for the American Civil Liberties of Washington, and Alize Bojani, the Washington Policy Counsel at Legal Voice. We will move to the next slide now. Me again. Oops. We can go back one slide for a second. So we're going to start off talking about the current landscape because a lot has changed. 3 years ago, when the Supreme Court overturned Roe versus Wade in the Dobbs decision, bodily autonomy became a confusing patchwork of laws. Your rights to control what happens to your body should not depend on where you live, but that is the reality under the current court. We continue to see escalating attacks on abortion rights, LGBTQ rights, especially those of trans people, and judicial activism that expands a right-wing agenda that ignores laws, science, good policy. Today, we're here to both understand what's happening on the national level and what the implications are for Washington state. We must not only react to attacks, but hope to explore opportunities to be proactive to protect and potentially expand access in Washington. So today's agenda will begin with an overview of the post-Roe landscape for bodily autonomy nationwide. Then we'll pivot to 3 Supreme Court cases with a special focus on Washington protections and litigation. and end with Q&A. So please use the Q&A function to flag any questions that come up for you. All right, we will move to the next slide. So, abortion access, or lack thereof, depending on where you live. I think it's important to start off with what the reality is that many people live with today or die with today. Adriana Smith was a 30-year-old nurse in Georgia and a mother who went to the hospital because of severe headaches. She was sent home without proper medical testing that could have saved her life. After suffering blood clots in her brain, she'd been in a vegetative state since February. Although legally dead, her body remained on life support for months due to the hospital's concern about Georgia's strict anti-abortion legislation, which prohibits abortion after cardiac activity in an embryo can be detected. That went into effect after the Supreme Court overturned Roe 3 years ago this Tuesday. Her mother shared that life support ended on Tuesday, the 17th of this month, following a cesarean on June 13th. Currently, 13 U.S. states are enforcing bans on abortion at all stages of pregnancy. 3 others have bans like Georgia's that kick in after about 6 weeks. It's important to acknowledge that even when Roe still stood, almost 8 million women in the United States couldn't access abortion due to federal funding restrictions. They already had to take extraordinary measures to make decisions about their pregnancies and their health. This map shows the patchwork of how access has moved further out of reach for tens of millions of more people. The blue states indicate expanded access. The teal states have protections for access. The yellow states and territories do not have protections. The red states and territories are actively hostile. And the 13 Burgundy states have made abortion illegal. It is completely banned. Additionally, while North Dakota repealed their total ban last September, there are currently no providers in the state, and litigation about the ban's repeal is ongoing. Also, notice that Missouri is striped. That's because last year, voters approved an amendment to the Constitution to protect reproductive freedom. A state circuit court held the state's trigger ban and other abortion restrictions were enjoined because they were unconstitutional. However, this May, the Missouri Supreme Court temporarily blocked those injunctions, allowing the trigger ban to go into effect. The reality is the number of abortions in the United States increased in both 2023 and 2024. This reflects the greater availability of medication abortion, which now accounts for 63% of all abortions, as well as more people traveling out of state for care, a number that's doubled since 2020. Shield laws like Washington's are vital. Half the abortions provided by telehealth were facilitated by Shield laws this past year. While these facts mitigate some of the harms, everyone deserves access to their preferred method of abortion care in their own community. These have been lifelines for patients, but are now the anti-abortion movement's next targets. So far this year, 25 states have introduced at least 68 bills to restrict medication abortion. There's an active push to restrict travel for abortion care, which blatantly violates the constitutional right to interstate travel. Last year, over 155,000 people traveled out of state for abortion care. That's about 15% of all U.S. abortion patients obtaining care in states without a total ban. While minors are the focus of current travel restrictions, we know the people seeking to control women are only going to escalate. So far this year, 5 states have introduced 8 bills to criminalize people or organizations who help a minor leave their state to access legal abortion elsewhere. Idaho and Tennessee have already enacted these laws, though some components are still in court. Other state legislators and local officials have threatened to bar adults from leaving their states for healthcare. This year in Montana, legislators introduced but did not pass a bill that would have criminalized travel in or out of state for an abortion that's illegal under Montana law. The infrastructure to enforce travel bans already exists. Routine state and local traffic enforcement and immigration checkpoints are already widely used. The current reconciliation bill before the Senate and the House includes a provision to defund providers of abortion. And if it moves forward, 200 Planned Parenthood health centers in 24 states across the country are at risk of closure. On that note, we'll move to the next map, which illustrates another aspect of bodily autonomy. So this map reflects gender-affirming care for youth, or lack thereof, across the United States. I'll keep this brief, as Sadie will discuss Skirmeti later on. Bottom line, 27 states have passed laws against gender-affirming care for young people. About 40% of trans youth ages 13 to 17 live in states that ban the best practice for transgender youth in terms of medical care. So far this year, one state has passed a new ban and one state has expanded its existing ban. Kansas in February overrode a governor's veto to pass a ban, and in April, West Virginia removed exceptions from their previous ban. Now, the green states on this map indicate the 14 states, including Washington and the District of Columbia, that have shield laws, which protect access to transgender health care. Also, the two shield symbols are places where executive orders are in place. Note that Arizona actually bans best practice surgical care for trans youth, but also has a shield law based on an executive order. New Hampshire also has a surgical ban for trans youth in place. The 8 beige states and 5 beige territories neither have a shield nor do they ban best practices for trans youth. The peach states are the 2 that ban surgical care for trans youth. And the orange states indicate the 25 states that both ban best practice medical care and surgical care for trans youth, though the ban may not be in effect. 6 states in red make it a felony to provide certain forms of best practice medical care for trans youth. And on that happy note, I will turn things over to my colleague Vanessa to discuss one of the key national legal cases.
Thank you, Lychee. This case actually just came down from the Supreme Court today. This Kennedy versus Braidwood Management Incorporated. It was formerly Braidwood versus Becerra. Next slide, please. So what was at issue was preventive services without patient cost sharing. And it was a direct challenge to Section 2713 of the Affordable Care Act, which is the component that requires private health insurance plans to cover preventive services without patient cost sharing under certain circumstances, which is when they are recommended by the Preventive Services Task Force and a couple of other different expert committees. And these guidelines include coverage of contraception, PrEP medication to prevent HIV, and many other essential services. And the foundation of the original challenge in the district court was that a Christian-owned business and several individuals filed lawsuit in Texas. They were challenging the preventive services mandates on both constitutional and on religious grounds. Next slide, please. And In that case, in 2023, the U.S. District Court for the Northern District of Texas held that preventive services mandates, that the preventive services mandate violates the Constitution's appointment clause due to the way that expert committees are appointed, the Religious Freedom Restoration Act, because the plaintiffs didn't want to have to pay for coverage of PrEP, which they believe encouraged behavior that they thought was immoral and against their religious background. And a broad ruling in plaintiff's favor would have blocked the federal government from requiring health plans to cover many preventive services as they do today. However, the outcome was appealed, and so the ruling didn't take effect due to the pending appeal. It then in 2024 went to the Fifth Circuit Court of Appeals, and the appellate court agreed with the lower court that the Constitution's appointments clause was violated by the way that the expert committee was appointed. But it did narrow the ruling so that it only applied to the plaintiffs who brought the lawsuit, as opposed to the universal ruling that the district court had at first ordered. This next piece remains at issue. So the appellate court remanded to the lower court the issue of whether the HHS secretary's ratification of the ACIP vaccine recommendations and the HRSA recommendations regarding care for infants, children, adolescents, and women violated the Administrative Procedures Act. And that piece had been stayed for a long time pending the outcome of the Supreme Court appeal, which, as noted, just came down today. So that piece will be remanded back to the district court. That is the piece regarding the vaccine recommendations and the HRSA recommendations. So today, the issue that was before the court in the Supreme Court case was whether the structure of the U.S. Preventive Services Task Force violates the Constitution's Appointments Clause, and whether the Fifth Circuit erred in declining to sever the statutory provision that it found to unduly insulate the task force from supervision by the HHS secretary. The upshot of today's holding was that the Supreme Court found that the Affordable Care Act's requirement that most insurance plans cover preventive services without cost sharing is valid, that the Constitution's Appointments Clause was not violated by the way the U.S. Preventive Services Task Force was structured. Next slide, please. So what the outcome means for preventive health, why this is a win, is that preventive services have been preserved with no cost sharing under Braidwood. This suit only applied to certain services, that is, those recommended by the task force after the enactment of the ACA, which so effective March 23rd, 2010 and later. There were earlier recommendations that weren't at issue in this case, but some of the really key services that were preserved under this holding were for some lung and colorectal cancer screenings, medication to reduce breast cancer risk in women at increased risk, statins, hepatitis C and unhealthy drug use screenings, preeclampsia medication, preventive interventions for perinatal depression, PrEP or pre-exposure prophylaxis, and HIV screening for men aged 22 and older. And just to put that in context a little bit, a 2023 Kaiser Family Foundation analysis found that 6 in 10 privately insured people, or about 100 million people nationally, receive services covered under the ACA preventive service mandate in a typical year. And it was statins that are used to treat people at risk of cardiovascular disease that are the most commonly used preventive service that was potentially affected by this ruling. Next slide, please. So Washington law is would have offered some protections in the event that Braidwood had come down differently. So what you should know about Washington law is that it does provide for preventive services coverage. It requires non-grandfathered state-regulated health plans to cover the following without cost sharing. And that's evidence-based items or services rated A or B by the task force. And A is a high certainty of substantial net benefit. B is at least a moderate certainty of net benefit. Immunizations, preventive care and screenings recommended by HRSA for infants, children, and adolescents, and additional preventive care screenings outside of those recommended by the task force that are for women included in HRSA supported comprehensive guidelines. The three categories there in red, starting with immunizations, are based not on recommendations by the task force, but by ACIP, the vaccinations organization, and HRSA. So the Supreme Court has not weighed in on their constitutionality as yet. This is the component that will be heading back to district court. And this is important because all of this is relevant because although the statutory language intends to support evidence-based medicine, it's important that we recognize that the HHS secretary still has tremendous influence. And so along those lines, for example, on June 9th, Secretary Kennedy announced that he was firing all 17 members of ACIP and replacing them. And then on June 11th, he announced that the appointment of 8 new ACIP members with varying degrees of relevant experience. Some had ties to anti-vaccination groups and causes. So even though the structure of the ACA ostensibly would have kept the political influence out of the evidence-based recommendations, we may see some changes there anyway. Next slide, please. Back to the state law, it does protect some Washingtonians, definitely not all. It protects only 1.2 million Washingtonians. And you'll see this is the individuals it covers are those that are regulated by the state or in plans regulated by the state. And so you can see on the slide the breakdown of all of the various coverage forms that are not considered covered under the Washington state law. So additionally, I should note that Medicare enrollees are likely protected under federal law under a different set of statutes. And the state has limited authority to regulate other types of coverage that are not included here. And in particular, this is relevant to large employer-sponsored plans governed by ERISA rules. Next slide. I will hand this off to Sadie now for the Skermeti case.
Hi, everyone. I am Sadie Sapath-Michwaya. I use she, her pronouns, and I am the new Health Policy Program Director for ACLU of Washington. So happy to be with you all here today. So if the Braidwood case is about who deserves access to preventative care, Skermeti just goes a step further on whether people or some people deserve care at all, especially trans youth. Like, who gets to decide what care a young person receives when their life and identity is at stake? Is it the parent or is it the state? And we'll also talk a little bit about an additional topic of the Washington Safety Act, as in parental rights. Next slide. So what's the issue? So the United States versus Skermeti decision, which was decided as of June 18th. And in this case, the U.S. versus Skermeti was 3 transgender youth and their families who in a Memphis area provider who was challenging a state law, so Senate Bill 1, that prohibits medical providers from prescribing medical treatments to transgender youth, such as puberty blockers and hormone replacement therapy to transgender minors, which are treatments that are available to non-transgender minors. And so within this decision, there were two questions that were at stake and proposed to the courts: whether or not Tennessee's current law banning gender affirming care violates the Equal Protection Clause of the Constitution. So basically, did the law discriminate based off of sex or transgender status by banning solely youth seeking gender affirming care? And then whether or not Tennessee's law interferes with constitutional rights of parents, restricting the authority to make medical decisions for their doctors in consultation with healthcare providers. Next slide. And so the question is like, where is this case now? Where is it at in the courts? So as of June 18th, the court basically agreed with the Sixth Circuit Court's decision to allow the law that's currently in place to take effect, finding that Senate Bill 1 of Tennessee does not draw extensions based off of sex and transgender status. As a result, the court only applied that rational basis review and collected and concluded that Senate Bill 1 may remain in effect. So basically, just to kind of break that down a little bit, is that the court is basically saying that the law does not discriminate based off of gender and transgender status, and they don't really have to give it touch review. They will just check the law, see if it has any reasonable justification, and then ultimately the courts decided to uphold the current law banning gender affirming care for transgender youth in the state of Tennessee, even with parental consent. Next slide. And so far we've looked at what Scrimeti is about and where it is. Now I kind of want to talk about how this case kind of impacts Washingtonians and what to know. So in the case of U.S. versus Scrimeti, the Supreme Court upheld the Tennessee's ban on gender affirming care for minors. Now, this decision does not overturn or change any laws in Washington state. Gender affirming care, including minors with parental consent, remains legal and protected under Washington law. So I want to make that very clear. But other impactable factors to consider is providers. And while legal protections remain intact, Washington's healthcare infrastructure is experiencing increasing demand. So many providers are reporting longer wait times due to influx of out-of-state patients seeking care. And some of those clinics have wait lists that are over 300 people. So keeping that in mind. And then also access challenges. So even with legal protections, access to gender affirming care can be difficult. Advocates have reported shortages of affirming care physicians and a call for expanded training and support for providers. And then also due just to federal pressure. So with ongoing the state of the world and federal actions, including executive orders and funding threats, they may indirectly affect care availability. Washington is actively challenging these courts. Next state. And then also talking about other possible factors. And so I wanted to uplift that even though Scrimeti has the impact to threaten access to and providers, the brunt of the impact isn't just a policy, it's really personal. It's for youth who must flee hospital homes and states. Washington has tried to create a shield of protection. So I want to talk a little bit about Washington Safety Act. So Washington Safety Act is protection, a law for youth who are identified as homeless and runaways who are seeking gender affirming care. The act specifically states that host homes who are aware that youth that are away from home without permission do not need a parent or legal authorization if there is a compelling reason to contact the parent or guardian. And that compelling reason is labeled as youth that are seeking gender affirming care services or healthcare services. This act allows the host homes to notify shelters, to notify the state instead of maybe possible unsafe parents. And so I kind of gave you a little bit of a connection, is that the Scrimeti case and the Washington Safety Act are in connection, but in opposite poles. So one bans care even with parental consent, and the other one protects access even without it. Scrimeti frames gender affirming care as not a fundamental right under the Constitution, but Washington Safety Act frames that access to care is essential, a tie to youth safety and autonomy when it comes to compelling reasons like gender affirming care. And so I want to again make note is that even though Scrimetti's decision does not repeal Washington's Safety Act, it just lays a legal framework that this act can be targeted in other interstate challenges and potential lawsuits for out-of-state parents and Washington state providers and shelters. Next slide. And I'm going to turn it over to my good colleague, Elise.
Thank you so much, Sadie. Thank you to everyone who's here with us today. I know that it can be a really rough time. I want to name that this week it is 3 years since the Supreme Court overturned Roe v. Wade in the Dobbs decision. And ever since, they have continued to make incredibly damaging opinions that have far-reaching consequences and have eroded the rule of law, along with this administration. You will notice a through line in these cases that we are talking about today. There's the same theme of choice and autonomy being stripped away. In the case of Medina versus Planned Parenthood South Atlantic that I will be discussing today, the question focuses on the issue of lower income people and if lower income folks can access or choose their own healthcare providers. I will also lightly touch on the status of EMTALA, the Emergency Medical Treatment and Labor Act. Next slide, please. So what's at issue in this case? It's about the freedom of choice under Medicaid. This provision, as listed in the statutory note right there, guarantees that Medicaid beneficiaries have the right to obtain medical services from any provider who is both qualified to offer those services and is enrolled in the Medicaid program. These provisions ensure that patients have the right to choose their healthcare provider and that the government cannot arbitrarily remove providers from these programs. Furthermore, individuals harmed by a violation of these laws sometimes have something called a private right of action, which is the ability to sue in order to enforce their rights. While the Medicaid Act does not explicitly have a private right of action, Medicaid beneficiaries have been able to use a civil rights statute, often you may have heard of it called a Section 1983 claim, that gives individuals the right to sue if a state actor is violating their rights under rights secured by the Constitution and laws such as the Medicaid Act. You can see in this map here that Planned Parenthood provides family planning services to Medicaid beneficiaries in almost all states. Some people are confused about how Planned Parenthood can get federal dollars when federal dollars are not supposed to go to abortion. Well, while Medicaid cannot cover most abortion services, it does cover family planning, and it pays for about 41% of US births. Planned Parenthood offers many family planning services, and they are enrolled in the Medicaid program to provide basic reproductive health care, from pap smears and contraception to STI testing. Some centers, including the one in South Carolina at issue here, also provide general healthcare services such as flu vaccines and annual physicals. Importantly, South Carolina has banned abortion after 6 weeks. So the Planned Parenthood centers in South Carolina do serve primarily non-abortion care. Next slide. So what happened in South Carolina? In 2018, the South Carolina governor demanded that the State Department of Health remove Planned Parenthood as a provider under Medicaid. Julie Edwards, a local Medicaid patient who used Planned Parenthood for birth control and other obstetric care, sued the state. Planned Parenthood supported her and joined her in this suit as well. The Fourth Circuit agreed and ruled in favor of Julie Edwards, holding that Medicaid beneficiaries do have a right and a freedom of choice provision under the Medicaid Act, and that South Carolina could not bar Planned Parenthood from its Medicaid program. As y'all may have heard of this organization, Alliance Defending Freedom, they are a very prolific anti-choice organization, and they are the representatives of the state of South Carolina. So they are the lawyers and appeal to the US Supreme Court. The Supreme Court issued its opinion just yesterday. So you are getting all of our hot takes very, very fast. The Supreme Court reversed the lower court's decision, holding that Medicaid patients do not have individually enforceable rights under the specific provision to challenge provider exclusions under the freedom of choice provision. Their reasoning literally is that the word rights was not used in the Medicaid Act. And Justice Gorsuch frames it as a separation of powers issue, that this is a matter for Congress and that courts cannot get involved in policy decisions best left to legislators. There's some more nitty-gritty into how the court came to this conclusion that I'm happy to chat with anyone about, but I don't think we need to get into all of the specifics of the spending clause unless someone's really excited about it. And next slide, please. So impact on Washington residents. This Planned Parenthood case is specific to South Carolina. However, the template that the South Carolina legislature and governor are using is one that federal Congress members are attempting to use nationwide that would impact every single Planned Parenthood in the country, and state legislators are attempting to replicate. So currently lawmakers in Congress are passing a version of South Carolina's Medicaid ban, which would block Planned Parenthood and similar providers from receiving any federal funding, including Medicaid reimbursements. We are still watching to see where that is in the Senate budget bill. The parliamentarian has not yet ruled on it. It is under consideration. So we don't know if that will pass and if Planned Parenthood may be banned nationwide. If it is, the consequences would be incredibly severe. 1/3 of Planned Parenthood clinics nationwide could be forced to shut down, especially in states where abortion remains legal and demand for services is high. In Washington, Planned Parenthood stands to lose approximately $11 million in Medicaid funding. That would impact services being offered in Washington. Washington is already an services hub. People from Idaho and Texas come to Washington in high numbers to receive abortion care, to the point that some Washington residents go to Oregon for abortion care because the wait lists are already long here. Finally, thousands of patients could go without essential services, not just abortion care, including birth control, cancer screenings, STI testing and treatments, and routine reproductive health care. Furthermore, in Justice Thomas's concurrence, and his concurrences are always ones to watch because they signal where the court is thinking of going next, he leaves the door open for further limiting the use of Section 1983 civil rights suits. 1983 suits, once again, are the main way people whose civil rights have been violated by states can seek remedy. These are often used in cases involving police brutality and excessive force, as well as prisoners' rights. He states in his concurrence that he thinks Section 1983 suits should be limited to how they were used and understood in 1871. Next slide, please. Finally, I just want to take a moment to talk about the Emergency Medical Treatment and Labor Act, EMTALA. You may have had some news come up earlier this year, maybe last month, that the Trump administration repealed a Biden-era guidance that clarified hospitals' obligations under EMTALA. The guidance from the Biden administration required hospitals to provide abortion care when necessary to stabilize a pregnant patient in an emergency, regardless of conflicting state laws, such as Idaho's total abortion ban. Nationally, this repeal can create legal uncertainty for hospitals in states with abortion bans. Pregnant patients in medical emergencies may face delays or denials of care. You may have already seen the news about the Florida legislator who had trouble getting care for her ectopic pregnancy. Providers may fear legal consequence for offering life-saving treatment, and we have already seen that as well. However, Washington State will not be impacted. Washington has taken proactive steps to ensure emergency abortion care is protected. Earlier this year, the Washington State Department of Health adopted emergency rules to incorporate federal EMTALA protections at the state level, including emergency abortion care. And the Washington State Legislature passed a bill to codify and clarify that hospitals must provide abortion care when medically necessary to stabilize a patient. They are also prohibited from prioritizing the continuation of a pregnancy or the health of any embryo or fetus over the health and safety of the pregnant person without that person's informed consent. So there are some bright areas of hope as we continue forward. And it's important to remain engaged both at the state level and at the federal level as we see what is coming down the pike. And I'll hand it back back to Lychee, I think.
Yes, thank you, Alize. And thank you all of you for spending part of your lunch with us. So as a reminder, if you have any questions at all, please put your questions in chat. We will circulate the slides and the recording to attendees after the webinar. But first off, a question for Vanessa. Do you know why HIV screening is limited to men 22 and older?
Sure. It may have predated the ACA. It isn't that coverage without cost isn't recommended for HIV screening for adolescents and women. It's that it didn't fall into that post-2010 task force recommendation coverage period that was at issue in the lawsuit. So that slide where I had listed some of the preventive services that would have been affected by the lawsuit, that was not a comprehensive list. That was just a few of the very important recommendations that were at issue in the lawsuit. But there are plenty of other recommendations that are still required to be covered without cost. And there are other recommendations that would have been affected by the lawsuit that were not on that list. You're on mute, Lychee.
Thanks, Vanessa. Sorry about that. And thank you for your answer. So we know that today we're gathered to talk about bodily autonomy, but there have also been a whole slew of Supreme Court case decisions that have come down. So curious if any of the panelists would like to highlight any other Supreme Court decision that we've seen thus far that alarms you, or that you would like to take this opportunity to talk about.
I can start, Lychee. There's quite a few that alarm me, but this morning we had 6 opinions come down. One of them was Trump v. Casa. That was the big one that I know a lot of people are watching around the question of preliminary injunctions. And I know that's not what a lot of people expected me to say. The headline of the case is around birthright citizenship, and it's focused on the executive order that President Trump released on his first day in office, saying that birthright citizenship would be limited to people whose parents are citizens or lawful permanent residents, or at least one parent. Immediately, there were multiple lawsuits stating that this is unconstitutional, specifically because of the 14th Amendment. And 3 courts in Maryland, Massachusetts, and Washington issued nationwide injunctions to stop the enforcement of this executive order. The Trump administration appealed, and none of the courts of appeals were interested in taking it on and left the preliminary injunctions in place. They further appealed to the Supreme Court in May on the emergency docket, and that was the opinion released today. Justice Amy Coney Barrett wrote that the preliminary injunctions were being overused. And in similar, as I mentioned, Justice Thomas's concurrence in Medina earlier, similarly, she said when preliminary injunctions were first considered in English law in, once again, the 1800s, there was no concept of a nationwide injunction. So there is belief that nationwide injunctions are being abused. And so they remanded to the lower courts to think about whether a narrower injunction would work better in this case. She also noted that complete relief in the Casa case is achieved by an injunction solely for the individual petitioners in this case. And they were also remanded to think about the standing for states and how injunctions might work, since the states are saying they would also have a huge burden if the executive order is in place. And finally, they allowed the executive order to go into effect in 30 days. So the next 30 days will be really important to watch to see what actions the district courts take, particularly the Western District of Washington, which is where our Attorney General, Nick Brown, is bringing the birthright citizenship case on behalf of Washington citizens, Washington residents.
Thanks, Elise. Birthright citizenship, I think, certainly has implications for many people, and implicates what the rule of law will look like moving forward. Vanessa or Sadie, do you want to highlight specific Supreme Court cases or decisions? Sadie?
Yeah, I think I was gonna, as soon as you said other court decisions, I was like, birthright citizenship. That's the only one that I've watched really closely. Yeah, and I feel like it's just gonna open up a door to see about like how we're going to move forward, how our law is going to move forward. So I will only add comments to what Elise said, that it's just a domino effect of other things. So that's the only one I've been watching really closely.
So we do have a question about maternal mortality rates in red states. We know maternal mortality has been a topic of conversation, and one with significant disparities, both geographically and among demographics. Elise, do you want to say more about Texas or other red states, or Sadie perhaps?
Yeah, Sadie, if you have, I will defer to you.
I want to make sure that I answered the question. You were wanting to know if we have been watching maternal mortality rates in Texas. The answer to that would be, I personally have not, but when I lived in Texas, I'm originally from Texas. For those folks who are new to who I am, I'm originally from Texas, and I just moved to Washington about 3 months ago officially. And when I was in Texas, yes, we were watching maternal mortality rates, and I think making it understandable and also changing, trying to write laws better for it. But the answer to your question is yes, they have been watching it in Texas. The answer and the status of that, I wouldn't know it enough to be able to give you an update now that I've transitioned on.
I was able to pull it up real fast. Maternal mortality as of April 2025 has risen 56% in Texas in the first full year of the state's abortion ban. That is significant. The other thing I want to flag just in general about maternal mortality and reproductive health care is that intersection with immigration and immigration health care. The more we ban or talk about illegal immigration, or we talk about taking services away from people, reducing people's access to healthcare, the less they are able to have good healthcare and good health outcomes. When we talk about a 56% increase in maternal mortality, we're not even seeing the further marginalization within that number, how much higher that number tends to be for Black women and Black folks seeking healthcare, how much higher that number tends to be for immigrants who often are now afraid to even go access hospitals because of ICE checkpoints and other issues with state deputization as immigration enforcement. So there are multiple intersections and issues around reproductive health care, and it's why I always say that immigration justice is also reproductive justice, and we must talk about them together.
Thanks, Elise. And a question for the lawyers among us. Question about the case of Adriana Smith. An anonymous attendee is curious whether a durable power of attorney for healthcare would have had any say in that situation.
It depends. My classic lawyer answer, it depends on the laws of that state. Some states do have laws on the books that say a power of attorney is suspended if the person is pregnant. Washington State had a similar statute that did suspend people's end of life decision making or power of attorneys in healthcare settings if that person was pregnant. And we recently changed that law this session, so that's great. And Idaho also had something similar, and this was a case where Legal Voice did actually litigate to overturn that, ensure that the pregnant person's wishes were respected. I unfortunately do not know what the situation is in Georgia.
I will say in Adriana Smith's case that her mother was very clear and outspoken in saying that as next of kin, she did not want her daughter used as an incubator, and that the dialogue with the hospital was oddly not about abortion, but they had read Georgia's law so broadly as to say, even though removing life support isn't functionally an abortion, we do not feel, as the hospital in Georgia, that we have any choice but to keep her alive over the wishes of her family, because she was pregnant at the time when the lack of appropriate medical care made her brain dead. So really tragic and disturbing case that illustrates some of the broad implications and potentially unintended implications for the laws that are being passed. I don't see other questions in Q&A, so but does anyone want to take a moment to ask a question before we conclude?
Sorry, y'all. I guess you're here for the Elise 20 minutes. The last one I just wanted to flag was the other one of the 6 cases that came down from the Supreme Court today, which was Mahmoud v. Taylor, specifically about different books and access in classrooms to stories that have more inclusive families featured. And the Supreme Court today said that that did burden people's religious freedoms. So I haven't had a chance to deeply read that case. I had some other cases to look at. It is on my list, but just wanted to mention that that was something else that came down today as well that is going to have serious impacts. And I know Justice Sotomayor in particular had an incredibly strong dissent. And in case anyone's following along, she's mostly stopped saying I respectfully dissent and has moved straight to just plain dissents.
Thanks, Elise. Okay, we did get another question. So the question before us is, does anyone have any words or wisdom for lawyers in the audience who feel like we work in a system that's brutally unjust and no longer follows the rule of law? You know, easy softball question.
Be in community, folks. That's all I've got to say. We're hoping to go to Trans Pride tonight. Please, I mean, check in with your folks, take a break, and then come back fighting.
Yeah, I mean, it feels a little wonky for me because I feel that even in a policy perspective. So I want you to know that you're not alone. I think the inspiration is just take time for yourself and give yourself grace because you're gonna need it. I don't like to use the word very often of being resilient, but I'll use the word being steadfast, and just remember like your advocacy why of why you want to do this work and what makes you get up, and just keep that in a little sticky note or something next to you to remind you just to keep going. I would say that.
And I would add that there are organizations that are focused on attorneys, helping protect the rule of law. And you might want to start with your bar association. The Washington Bar has issued statements regarding rule of law and its position with respect to lawyer obligations in that regard, and I believe launched a program. But there are other organizations supporting attorneys who are concerned about such things that you might be interested in joining, volunteering with, that sort of thing.
You can also volunteer with and join the newsletters of all of our organizations, NoHLA, Legal Voice, ACL, everyone knows ACLU. So you can keep updated with the work we're doing. I strongly believe in being engaged at the state level because that is where we often see the most direct changes. So think about what it means when our state legislators say we have a huge deficit and are cutting public health funding in this moment. What does that mean, and what can we as residents of this state do to push our legislators to have an abundance mindset when it comes to our rights and access to healthcare?
I would also add, I'm not sure this counts as inspirational, but yay, New York City. I feel like in dark times, it is important to celebrate the victories and the signs of hope. And I think having a 33-year-old son of immigrants defeat a serial sexual harasser is a good sign for democracy, and also speaks to the power of organizing, of knocking on doors if you feel safe doing that, and of collectively working towards a better future where all of us are seen as human, not just some of us. So thank you for spending some time with us and learning a little bit more about bodily autonomy and the Supreme Court. We will circulate the recording and slides, and take care and try to stay safe all. Thank you for spending some time with us.